Hello. So what we're going to look at today is judicial precedent. Now, it might feel like we're going to have a bit of a Latin lesson. There are quite a few kind of Latin terms, but like anything, what we have to do is simplify it. So we need to use cases as examples. There's quite a lot of factual content for judicial precedent, and then at the end of the topic, we will look at the evaluation of whether judges should be making law or not. Okay, so first of all, what is judicial precedent? Well, judicial precedent, difficult to say, is a source of law where past decisions of judges create law for future judges to follow. So it just kind of makes it a quicker, fairer, more consistent process. So if there was a point of law, so like a legal issue that was answered in a case previously, then it saves time and money, and you just follow the previous decision. So the hierarchy of the courts is very important here. So what happens is the higher courts will bind the lower courts. So the Supreme Court, if there's a case that, remember, it has to be appealed all the way up, if there's a case that gets to the Supreme Court, then all the future cases in any of the courts, including the Supreme Court and those below it, so Court of Appeal and High Court, will have to follow the precedent set by judges. Remember, you normally have about 5 appeal judges. So linked to judicial precedent, if you've got a question, explain the concept of judicial precedent. It may say explain the concept of Starry Decisis. So you would need to talk about what judicial precedent is, so judge-made law, and the idea that judges are creating decisions for precedents for future judges to follow. Starry Decisis, our first bit of Latin for the day, means stand by what has been decided. Let the decision stand. So what this means is a court that's hearing a similar point of law in a present case should follow a previous decision. Now, the case example I'm going to use is Dica, D-I-C-A. Mr. Dica knew he was HIV positive and he had unprotected sex with 2 women. They both caught HIV. Now, the courts had never had a case like this before, and they had to decide, was giving somebody HIV GBH, was it serious harm? Obviously, when the Offences Against the Person Act was made in 1861, nobody knew anything about HIV. It wasn't a thing, it didn't exist. So in the present day, in the courts, they had to decide, is biological GBH a thing or not? So giving somebody HIV, is it what we call biological GBH? They decided yes, it was. So this means they upheld his conviction. He was guilty of GBH. But it also means that in the future, if there are any similar cases, then those people will also be guilty of GBH, or they could be guilty of GBH. Okay, 2 more Latin phrases to look at, and then we will look at examples of what these are. So ratio decidendi. When judges give a speech, it's called a judgment, and this speech gives the reasons for the decision. So in that judgment, there's a lot of talking, a lot of writing if you read it. The ratio is set out. It appears somewhere in that judgment, and this is the binding part of the speech. So this sets the precedent for all future cases to follow. So in the case of Chan Fook, they talked about bodily harm. Does it include mental harm? And they said, yes, it does. So that was the ratio. In Dica, think about Dica, we've just spoken about Dica. The question for the courts was, is there such a thing as biological GBH? Is giving somebody HIV biological GBH? And they decided yes. So that was the ratio. So all 5, there are normally 5 judges, will give a speech. They don't all have to agree. It could be a majority, so it could be 3-2 or 4-1. If it's unanimous, that means all 5 agreed. So a unanimous decision, all 5 agree. If it's a decision, for example, 3-2, then the 2 judges that disagree in that 3-2 are called dissenting judges. And that's okay. They give their reasoning. The ratio will be, or ratio, it doesn't matter how you pronounce it, will be in the majority speech. So that 3-2, the ratio will be somewhere in the speeches of those 3 judges. Now, it depends upon the court hierarchy as to whether the ratio is binding to other courts. So when the Court of Appeal sets a precedent, the courts below have to follow. But if in the future there's another case and it manages to get to the higher court, the Supreme Court, then they don't have to follow the lower courts. So just know your court hierarchy here. So, it's the Supreme Court, it's then the Court of Appeal, Civil or Criminal Division, then the High Court, then the Crown Court if it's criminal, and then the County Court if it is civil. So that's the ratio, so it's the binding part. What you've also got, whilst they're there, judges like to talk about other things. So that's called the obiter. This means other things said by the way. And this is not binding. It can, however, be used as a persuasive precedent in the future. So judges may discuss things as if the case facts were different. So let's use Dika again as an example. The key issue of the case was, is giving somebody HIV biological harm? And they said, yes, it was. That was the ratio. But they didn't all then just go home. The judges would have sat there and they would have thought, well, okay, let's discuss some other things. What if somebody gave someone else herpes or chlamydia? And I haven't read the judgment of Dika. I should really, shouldn't I? But if you were to read it, you would find some other things that they talked about. And they probably talked about levels of sexual harm and consent and other things in the judgment. So obiter, it's not binding. It's useful for future judges though, because they can look back and think, oh, has anyone ever discussed other STIs? Good example as well of the ratio and obiter is the case of Howe. So Howe took part in a killing. One of the murders he was just a part of, and I say just, he helped torture them, and in the other he actually did the murder, but he was guilty of 2 counts of murder. He said he'd been threatened, so he tried to claim the defence of duress of threats, and the court decided the ratio, duress of threats is no defence to murder. And then the obiter, whilst they were there, they discussed, is duress of threats a defence to attempted murder? And they turned around and said, no, we don't think that it is a defence to attempted murder. So that was the obiter. That was not binding. Now, the case of Gotts, a few years later, you've got the 16-year-old boy who was threatened by his father and told to murder his mother. He stabbed her, but she didn't die. So he was charged with attempted murder and used the defence of duress of threats. But the courts decided to use the obiter from Howe, where Howe had said, remember, obiter, duress of threats is no defence to attempted murder. And in the case of Gotts, they decided that Gotts should be guilty. He would not be allowed the defence of duress of threats. So they didn't have to decide that, but they used the persuasive precedent set out in Howe that duress is not a defence to attempted murder. And now Gotts has set a precedent, so that was the ratio of Gotts. Another good example, all students love it, is the case of Brown, sadomasochism. What happened here was you had 5 men who were causing each other pain during sex. It involved fish hooks and nails and pins and stinging nettles. You can, have a Google. And the issue was, can you consent to ABH or GBH? The ratio of the case is you cannot consent to ABH or GBH unless it's a recognised exception, like surgery or sporting events. And they said sadomasochism was not, it was only 3-2, sadomasochism was not a recognised exception. So the ratio is sadomasochism is not a recognised exception. You cannot consent to ABH or GBH. Okay, so tune in for the next video, which is going to look at the different types of precedent.